Hello and welcome to Bulletin 138. A few interesting cases to mention. The first is one of Permiwin, where basically through a complex set of transactions, one presumes a kind of gift and loan back situation, a person who started off with an estate of around 3 million finished up owing a trust controlled by her son of $3 million. In the event, the two daughters had brought a family provision claim, but of course on that basis that those transactions being valid, there was no estate to satisfy the family provision claim. The judge was prepared to, number one, remove the son as the executor and also say that the consideration of the validity of the transactions in a family provision claim was not appropriate and that they had to be determined separately. So just an interesting case, I think, on what happened there, presumably to defeat family provision claim by the two daughters who'd brought the claim, and we'll wait and see just how valid the complex transactions were in the end event. The next one is a revocation of a grant. In this case, probate was obtained of a will of 2010, but there was a subsequent will, 2014, where there was only a copy in existence. The issue was resolved and it was agreed that the 2014 will, copy of it that is, should be granted probate and the earlier grant be revoked. The reason the court was happy to acquiesce in that was that the copy of the will on its face showed that it had been duly executed and therefore the presumption of knowledge and approval existed. As well as that, they said that there was basically nothing to establish that in fact the usual presumption that if somebody holds a will and it disappears in their possession, then there's a presumption, unless there's evidence to the contrary, that it was destroyed with the intention of revoking it. There was no evidence here that that was the case, and the court granted probate in solemn form of the 2014 will and revoked the grant of the 2010 will. The final main case referred to, Collins and Marinovich, was a complex set of arrangements really, but fundamentally a mortgage was provided that on the death of the mortgagee that the loan would be forgiven, and there was a subsequent will where the benefit of the mortgage was given to another person, a friend of the deceased. The issue was whether you could take the provisions that forgave the indebtedness out of the mortgage and say that they were revoked by the earlier will, they were testamentary in nature, and they were revoked rather by the later will, and the court said no, that wasn't the case, and in fact the forgiveness, as it were, of the sum due under the mortgage was effective. It's worth a read. It just showed some quite creative, I think, arguments about whether those provisions in the mortgage were testamentary or not and could be extracted from the mortgage and thus have been revoked by a subsequent will. Anyway, I thought that were interesting cases. There's a final little case of McNamara, and it was a case where the judge wasn't satisfied that Section 18, the ability to approve an informal will, would apply. What happened was simply that the will was drafted obviously on instructions by the solicitor. He provided it to the client, but the client didn't ever sign it, and the issue was whether that would satisfy the fact that it was prepared on instructions, would satisfy the informal will requirements, and the judge said no. The fact that the person hadn't signed it, it was clearly a dilemma for him. His wife was against children of the first marriage, etc. And I like the wording that the judge used. He said that the explanation for not signing the will heralded an obvious explanation about the conflict of loyalties between the person who'd given instructions, the current wife, and his daughters. So just again reinforcing the fact that the courts won't approve a will unless it's quite clear that the document, whether it's a video or whatever it may be, was intended to be the testament, the will and testament of the deceased. Thank you.